Okay, so I'm joined by trial attorney and federal litigator Alexis Rosenberg, as well as civil rights attorney Joe Richardson. They're here to break this down with me. Alexis, I'm going to start with you. What do you think about this line of direct examination with this witness? What do you think about that purchase of bleach? Is that going to be problematic for this defendant?
First, thank you for having me. I do find it's problematic. I mean, we also have had testimony about the fact that he arrived at the store much earlier, thinking the store was open. So it was very important, apparently, for him to get this bleach. Obviously, you know, the defense is saying not for criminal purposes, but you know, why is he more or less pacing back and forth to get 2 bottles of bleach at 7 in the morning?
Yeah, now, of course, there's going to be an argument from the defense that there was a non-nefarious purpose for this purchase of bleach, and we probably expect that at the time of summation. But let's talk about the defense right now. And Joe, I want to get your thoughts on that cross-examination. It was brief, but do you think it was effective?
Well, I mean, you know, he just asked a couple questions to make sure that, you know, it was airtight for his mind. I wouldn't say that it was ineffective, but it certainly didn't help his client at all, right? I mean, this is an individual who doesn't have a dog in the fight. He works at Walmart. He's a manager. He understands what he's doing. You know, it was just sometimes when you really don't have a lot on cross, you'll ask a couple of clarifying questions just to make sure. So he's making sure, oh, this is the store identifier, things like that, to make sure there's no, you know, found mistake there, like it's a different store or something like that. He'll just ask a couple clarifying questions and move on. There certainly wasn't a lot to be gained other than to confirm the basis of what he was saying.
Yeah, no, absolutely. And Alexis, you know, there's no jury here. This is a bench trial. So perhaps would you agree that if there was jury there, that defense counsel would feel the need to perhaps ask more questions? So, you know, the effect on the jury is that this witness may have some credibility issues or something like that.
Well, exactly. When you're before a jury, there's more of a show. It's more theatrical in nature because you're trying to present it, keep the jury interested in what you're saying. So anytime you have a bench trial, it does take away from some of that. It also can limit those questions that you may ask that are for that purpose before a jury opposed to on a bench trial.
Yeah, Joe, this is a circumstantial case, as many cases are when they go to trial. So the prosecution has to connect the dots for the judge in this case and prove the guilt of this defendant beyond a reasonable doubt. So what is the importance of this particular testimony? Of course, you could infer all sorts of nefarious purposes for this bleach after young Briezia went missing. But what do you think that the argument will be, or what place does it have in the prosecution's case?
Well, I think that it's important because it lends to what this particular defendant was thinking based on what he was doing. The point was just made a bit earlier that, you know, this guy is coming to the store trying to get it open, you know, get it when it's open and comes back minutes later because there seems to be some urgency. But did he have to wash clothes at that time? That would be a lot of clothes. Did he have to clean up, you know, some blood spatters? You know, that might be closer to it. So they're really taking their time, and I think they have a better one thing that's good about not having the jury is that you have a good thought that your judge is going to understand the presentation, understand the value of the circumstantial evidence, and so therefore they can really put everything together piece by piece and take their time. That's why they've had so many witnesses about the search, about knocking doors, about DNA, the lady who was, you know, the officer who was pregnant and had more, you know, more heightened sense of smell, smelling bleach, which creates probable cause. So they can really kind of create, you know, this symphony, for lack of a better term, that lends to him being the person, particularly because it's a circumstantial case.
Absolutely. Great points from both of you. And stay with us out there. We're coming up after the break to recap body camera footage that the Davenport police officer that questioned the defendant after Briezia's disappearance had. Stay tuned. Okay, so that is the body cam footage that the judge was reviewing yesterday. That was body cam footage that was presented yesterday in court. And I'm joined by trial attorney and federal litigator Alexis Rosenberg right now. Also with me is Joe Richardson. He is a civil rights attorney. I want to get your thoughts on what we see in this body cam footage. Joe, I'm going to start with you. In the beginning, when that first interaction between the defendant and the responding officer that you see in the body cam footage there, I mean, he doesn't know some basic information regarding himself and also the victim. What are your thoughts on that?
Well, that never makes you feel good, I think, if you're a police officer. And I wouldn't be surprised if, I think the police officer was being truthful to the mom about, hey, listen, we got to work together and find this out, et cetera. But I think he's also at that time, he's probably suspecting this, who ultimately became the defendant, not befriending him, but giving him an opportunity to say some things. I mean, I think he understood. He acted pretty regular, pretty normal. That, how is it that this is weird, this is strange that this child disappears from under the noses of several people. And so, he's asking the things that he needs to ask. He can't get basic information. The two of them fall out, the mom and the defendant, but the defendant kind of lashed out first, which I thought was interesting because it was almost like he didn't want the mom to say what he was saying what she was saying to the police. And so, it would make your spidey senses tingle, I think, if you're the police officer, and then it just kind of went from there.
Absolutely. And Alexis, at this point, this officer is likely treating this as a missing persons case and nothing more. He's responding to the scene. 10-year-old Briezia is missing. He's sort of articulating that you wouldn't be surprised that, kids do this often. At some point, this turns into a homicide investigation. What are some of the things that you see in this body cam footage that would likely, sort of raise a red flag that officers might start getting suspicious that this is more than just a young girl running away?
I mean, the defendant was being very evasive, but I was also really surprised that I understand that the mother was extremely upset, but she didn't even have a picture of her child on the phone, which is highly unusual in this day and age. But his evasiveness and the fact that he really couldn't set a timeline. There was no set timeline. The girlfriend is kind of, I just went to sleep. That's what happened. I mean, there's no specifics. Usually when you have a missing child, and this particular police officer was being extremely patient, I believe, on how he was handling the situation with them, that you have, here's the picture, my child went missing. This was the last time I saw the child. And I understand this isn't his actual child, but the child was in his custody. This is what they were wearing. There was the facts, not just his lack of address, were just missing, and there were gaps.
No, absolutely. And Joe, there was that point where this officer gains entry into that apartment. Of course, we know, knowing how law enforcement works and knowing how, a search or consent to enter a property works in terms of the Fourth Amendment. What do you think this officer was doing when he entered that apartment? Of course, it seems very innocuous. It doesn't seem like he's any suspicious at the time. But do you think that this officer was using all his senses, so to say, because he was given consent to access that property?
Yeah, absolutely. With that consent, not only does he get some information in his interaction with, I think it's Andrea might be her name, who answered the door, he gets some sense with her interaction with her, whether she could be potentially part of something or part of being evasive and evasiveness. And then he goes and looks at things out of sorts, sees, seeks to look and see how much or how little things are out of sorts and how much the story jives. Where is she sleeping? So she's sleeping in your bed, but you're sleeping out here and nobody heard anything, no fights, no signs of struggle, things like that. And then you start to put together the notion that there's 3 or 4 people in the house, but nobody knows that this child gets removed or leaves and no one's around that they know. You know what I mean? And so he starts to probably put some things together in terms of saying, clearly, there are some issues here. And even though a lot of times it's a misunderstanding, someone is found close by, et cetera, the fact that they don't know anyone close by and that she's less inclined and likely to go off and to be a wanderer or anything like that would probably get his wheels turning a little bit, saying, perhaps there's something that's not quite right here. We go through our paces and make sure that it's not the thing that we all ignored. Oh, she was under the bed or, whatever else. But he's probably understanding that there's something that's amiss.
Yeah, absolutely. Great points from Joe and Alexis. We're going to take a quick break here at Law and Crime. Stay tuned. We will have more trial coverage on the other side of this break. Welcome back to Law and Crime, and we've been covering the Dinkins trial in Iowa. He's charged with the death of 10-year-old Breasia Terrell, and this is a bench trial. What does that mean? The defendant has decided that he doesn't want the jury to decide the verdict in this case, but rather than the judge. And before the break and before the last clip, I had asked Joe Richardson about his thoughts on the bench trial, why this defendant may have decided to go with a bench trial over a jury trial. And I want to ask our other guest right now, Alexis Rosenberg, who's a federal litigator, trial attorney, as to her opinion why this particular defendant may have made the decision to forego a jury, go bench, and have a judge decide his fate. Why do you think that?
But if you believe that the law is supporting your client's position, then you may want to go bench. That's one of the reasons. Although Joe did also bring up, if you think that the facts are going to make the jury hate your client, then that's another reason too. But a lot of times having the judge, when the law, the actual law, if you apply it and you take out the emotion, support, or heavily support your client, then you may advise them it's better to do a bench trial.
No, absolutely. I agree completely. This is the sort of case that a jury may be wrapped up in emotion. You have a 10-year-old girl who was found dead, and of course the defendant is the one who the prosecutor is saying is doing it. It's hard to divorce the sympathy, even though a judge will tell a jury you can't decide a case based on sympathy, put it aside. In a case like this, you can't do that necessarily. So I think you're right, Alexis, that there may be points in the law which may be favorable for the defendant in this case. Let's talk about what we just saw. The FBI latent print examiner and her testimony. Joe, do you think that testimony was able to move that ball down the court, so to say, for the prosecution?
Well, I mean, one of the things that you do with latent prints is, she went thing by thing, were there any latent prints here? No, why not? And so she can explain, and the judge can get, the jury doesn't have to feel one way or another about this because the jury's not there. The judge will probably understand that as it pertains to certain surfaces, latent prints are harder to extract or to have. And so it's not going to necessarily be penalizing against the prosecution because the judge is going to understand why latent prints are more likely to show up on certain surfaces than others. So this is one of those times where, as the prosecution, as they keep going, they'll probably mention they thought they found some prints here or there, or however that went. But as to the things that they didn't find prints on, there's an explanation, and you can rest assured as a prosecution that the judge is probably more likely to understand that and not allow that to be disqualifying in terms of them building their case towards beyond a reasonable doubt.
Yeah, and Alexis, when you have a jury there and you have forensic evidence which may not necessarily be 100 on point, and print evidence, latent print evidence, is something which a defense attorney can attack if the evidence is at all flawed in any way, the methodology, things like that. But there's no jury here to sort of do that theatrical show for in order to drum up that reasonable doubt. Where do you think the defense would go with evidence like this, the latent prints evidence, to sort of discredit the findings and put on a defense for the defendant in this case?
Well, I mean, there's not prints. So from a defense standpoint, that is a good thing. I mean, they're going to want to downplay there's no prints because they were cleaned. And that's where most juries would jump to when you have latent print evidence and there's no prints, that nothing has a print on it, and we've got a machete on top of a microwave. So, I think defense is just going to stick to the fact that there's no evidence. His print is not on anything. The fact that it's on a broom really doesn't, isn't that damning. So, I mean, I think they're just going to stick with that. But if you were going to go with the latent print, you would attack chain of custody. You would go through what exactly they did, how they tested, and those sort of things. If there is testimony later that something does have his print on it.
Right. And Joe, I want to put yourself in the shoes of the judge here, right? You're the trier of fact. You're going to ultimately render a verdict. What would be the evidence that you would be looking for in a case like this?
It's a circumstantial case. So the things that he's doing that are strong suggestions on the circumstantial side, certainly buying the bleach, the timing of buying the bleach, his conduct surrounding those types of things that lend to his state of mind, how well he did or didn't answer questions when he was asked things, particularly if you end up being able to contradict those things later, and just how well all of that's put together. He seems to have a lot of weapons and things. We don't know where that goes, though, if there's no evidence she was actually they would use a machete on her or something like that. So that's what I'm looking for.
Absolutely. So we're going to pivot after the break. We're going to take a break right now. We're going to go to the Thomas Randolph retrial on the other side, so stay tuned.